Bulbulia, and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I'm able to cover a vast, diverse range of matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please do get in touch. Two ways to get in touch. You can ring on the landline number which appears at the bottom of the screen. And as always, a very popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So the landline number for live calls and the mobile number for messages. If you send through your messages, those messages will be fed through to me here live in the studio, and I will be able to give you some advice in relation to those matters. Mashallah, even before we've come on today, we've had a number of questions coming in, which is fantastic. Please do continue to send your questions in. Okay, let's look at the first question that's come in. It's a popular question, something that comes up regularly, and it's a question from Brother Masoom. And Masoom says as follows, that he wishes to sponsor relatives from abroad to come to the United Kingdom for a short visit visa in January. What kind of documents do I need to provide to sponsor my relatives to come to the UK? Okay. Right, Masoom, you as a sponsor in the UK, the documents you provide are there to meet certain requirements. What you're showing by providing your documents is that you're in a position to sponsor your relatives who wish to come from abroad. So financially, you're able to sponsor them, and also that you're able to accommodate them here in the United Kingdom. So the vast majority of the documents that you will be providing will be documents which go to show that those requirements are fulfilled. So obviously you'll provide a copy of your passport to show your status in the UK, and I'm assuming you're a British citizen. That's fine. But now if we look at what type of documents do you need to provide in order to show that you're in a position to financially support your visitor who's coming to the UK? What kind of documents do we need to demonstrate that you're able to accommodate the visitors who are coming to the United Kingdom? Well, in terms of finances, you need to be able to show your financial position. So it depends on what type of income do you have. Example, if you're employed, you would normally then submit your 3 months wage slips, 3 months bank statements. If you wanted to, you could submit 6 months pay slips and 6 months bank statements. So that shows the level of income that you've got coming in, and that also shows that you're potentially able to sponsor your relatives who are coming from abroad. Ideally, what I advise clients is that the sponsor should have in the region of, if it's one visitor, about £2,500 in their bank account, and if it's two visitors, that they have around £3,500 in their bank account. That should be sufficient to meet the expenses of the cost of travel to the United Kingdom and their expenses during that short trip in the United Kingdom as well. So what I advise is, okay, you're going to show your income coming in, so you're going to be showing your wage slips and your bank statements, but have about £2,500 in your bank account saved over the last 3 months if you're sponsoring one person, and if you're sponsoring two people, have slightly more, have in the region of £3,500. So that then deals with the financial part of the sponsorship that you will be doing, Masoom. Now, if you're also going to be accommodating your relatives here in the United Kingdom, which is normal, then you will need to submit documents which show your ability to accommodate your relatives here in the United Kingdom. Now, those documents could be, for example, if you own the property that they're going to be coming to live in, then that would be your deeds to your property. So the deeds would confirm that you own the property. If you're a tenant at the property, then a tenancy agreement would confirm that you live at the property. If you're simply living with friends or family and they give their consent for your relatives to come and stay at the property, you would then need a letter from your whoever you live with, family, whoever it is, confirming that, hey, we're the owners of the property, here's a copy of the deeds here, or if they're tenants themselves, here's a tenancy agreement, and we give consent to the relatives who are coming to the UK to stay at the property. So you'd be looking at demonstrating your ability to accommodate your relatives in the United Kingdom by submitting these type of documents. Now, there was a time when you would normally submit a property inspection report, a report from an independent surveyor confirming how big the house is, who lives at the property, is there sufficient space for your visitor who comes to live at the property. To be quite honest, that's not really necessary in my experience anymore. The Home Office tends not to take issue with the availability of sufficient accommodation. Normally in the letter or in the sponsorship declaration that you do, it's sufficient to explain that, look, we have a property, whether you own the property, whether you're a tenant of the property, and it's got X number of rooms there in the property. These are the people who live there, and there is sufficient space for your relatives to stay at the property. So, in a nutshell, they're the two points that you're trying to address with the sponsorship documents. Your ability to look after them financially, and secondly, your ability to accommodate them here in the United Kingdom. Now, along with that, as I've just sort of touched upon, you could do a letter explaining who you are, your status in the UK, how you're related to the visitors, where you work, how much you have in savings, and what type of accommodation you have available for the sponsor, for the visitors, and the fact that you're willing to look after them. So you can explain all that in a letter, or if you want, you can do a sponsorship declaration before a solicitor, and they can write this out in a more formal way. So basically, that's what the position is. Masoom, if you want to sponsor a relative to come to the United Kingdom, you will be doing the letter, or through a solicitor, you will be doing a sponsorship declaration explaining all these things, and then submitting, along with the declaration, proof of your income, your savings, and proof of the accommodation which is available for the people that you want to sponsor to the United Kingdom. But Jazakallah, thank you very much indeed for that message. Now, the next query we've got coming in, and I'll just read it, is from Mudassar. And Mudassar says that he wishes to, he said, I want to sponsor my wife to come to the United Kingdom. I am in receipt of PIP. Do I need to be earning £29,000 in order to sponsor my wife to come to the United Kingdom? So thank you very much indeed for your question. Now, in terms of the financial requirement, you're quite right to pick up on this £29,000 requirement. That applies, generally speaking, to most spouse applications, but there are exceptions to that. And one of the exceptions is where you, the sponsor, you're in receipt of PIP, personal independence payments, because of your disability, or you're looking after somebody who's disabled and you're in receipt of carer's allowance. So if you're receiving those two benefits, then potentially you are exempt from the £29,000 requirement. Mudassar, the short answer to your question is that the £29,000 requirement does not apply to you. However, that doesn't mean that just because you're in receipt of PIP, that's a be all and end all, it's a free pass. It means that your wife satisfies the financial requirement, there is still an assessment of the income that needs to be done, an assessment or a calculation of the amount of money you've got coming in. So you do need to look at how much you receive in PIP. If you're in receipt of universal credit, you need to look at how much you get under, or how much you get in terms of universal credits. And if you're employed part-time or whatever it is, or even full-time, you also need to look at what your income is from that. If you've got savings, we can factor all that into account. So you still have to look at the fact that you're receiving PIP isn't sufficient in itself. It doesn't mean you no longer need to satisfy the financial requirement. There is a requirement, but it's much lower. It's in the region of approximately £145,000. I can't remember the exact figure, but that's the level of income you need coming in if you have no children that you're financially responsible for, if there's no rent or mortgage you're paying, and there's no council tax. You're simply sponsoring your wife to come to the United Kingdom to live with you. And I'm assuming from the question that you've sent in, Mudassar, that there's no rent, mortgage or anything of that nature to pay. In that case, you look at your PIP, you look at your universal credit, you look at any employment income coming in, and you count it all together. And the threshold that you need to meet is around the 145 mark. You can look it up. It's the level of income support a couple would receive. It's around that figure. As long as you've got that amount of income coming in combined on a weekly basis, you then meet the financial requirement and you can sponsor your wife to come to the United Kingdom. You don't need to be earning £29,000 per year. But Minister, thank you very much indeed for that question. I hope that helps. It was along the lines of, I think, what you had in mind, that potentially you are exempt from the financial requirement. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses, like measles and whooping cough, is rising.
If we're not vaccinated,
We're not protected.
and could get seriously ill. Risk of lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
well. The same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum. Welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, a popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. Now we've had a number of questions coming in. Let's look at the next question, and it's a question that's coming from Anam, and she's asking a question not relating to immigration matters, but a common question that comes up in practice. And she says that her husband needs to sign a power of attorney for Pakistan. Does it need to be prepared by a solicitor here? Does it need to be signed or witnessed by a solicitor here in the UK? So what Anam is asking is about a power of attorney for Pakistan. Might be to do with land or whatever it is, might be to do with a bank account. Whatever it is, what Anam is asking is whether that document has to be prepared by a solicitor here in the United Kingdom, and does it have to be witnessed before a solicitor here in the United Kingdom? Thank you very much for that question. Now, the short answer to that is that no, it doesn't have to be prepared before a solicitor here in the United Kingdom. As long as it's a properly prepared document, it could be done by lawyers or agent in Pakistan. Sometimes it's cheaper. As long as it's done properly, they could email over to you a properly drafted document for you, your husband, to sign here in the United Kingdom. So that's the answer to your first question. In terms of the document, I understand the document's been signed here, but does it have to be prepared by a UK lawyer? No, it doesn't. And sometimes I advise clients who may be a little sensitive over fees or have difficulty with fees that, look, the cheapest way, the best way to do it would be to simply ask a lawyer in Pakistan to get it prepared, to get it emailed over here, and to get it signed. You will save a lot of money if you do that. Now, if once the document's ready, whether it's prepared by a solicitor here or whether it's prepared by a lawyer abroad, the next question is, does it have to be signed before a lawyer here in the UK? Well, in relation to Pakistan, the position is that no, it doesn't. In fact, the requirement is that it has to be signed at the consulate of it before consulate staff. So you could, if you wanted, have that document prepared by a lawyer here, or get the document sent over to you from abroad, take it, whoever is signing or meant to be signing the power of attorney, they could take it to the consulate here. You'd need to make an appointment, you go there. The requirement is that it needs to be signed before consulate staff here. So that's the actual requirement, that it's got to be signed before consulate staff, Pakistan consulate staff. And when you go there, you'll need to take your passport, you'll need to take your national identity card, and it'll be signed before staff there, and it'll be signed, stamped, etc. So that's the actual requirement, that it has to be signed before consulate staff. Now that's the position with a power of attorney prepared for Pakistan. The position is different for other countries. For example, if you take India as an example, with India it can be signed before a solicitor here. There's no requirement for it to be taken to the consulate, for it to be signed before embassy or consulate staff. So that's the position with India. So every country has its own rules in terms of the kind of documentation that they're prepared to accept. If you take, for example, some Middle Eastern countries, their procedure is that it needs to be signed before a solicitor, and then it needs to be legalized. So once the solicitor signed it, etc., it then needs to be sent to the Foreign and Commonwealth Office, and you then have to get it legalized there. There are other places, some states in India, where the requirement is that the document has to be signed before a notary public. So there's a whole host of different requirements in terms of how the document is to be signed, depending really on where the document is to be used, which country it's going to be sent to. It could be signed before a solicitor, It could be signed before a solicitor and legalized. It could be signed before a notary public. It could be signed before a notary public and legalized. It could be signed before consulate staff. So it just depends on what the requirements of the place where you're sending the document are. But I hope, Anam, that answers your question. The next question that's come in, let me read the question out. I've not really had the chance to look at it. The husband is from abroad. She married him. He came over on a spouse visa. He's now got a British passport. He started showing his true colours. He's had several affairs. She's worried. She's worried. She has the name. She's named him on both properties, one of which is paid off. What can she do to protect herself and her children? What can she do to protect herself from him taking the children? Is it half and half? They have 6 children, all adults except one. Okay, so thank you very much indeed for that question. I do follow what you're saying. The husband that's come over from abroad, it looks like it's a very much a long-term marriage. The marriage has subsisted for 30 years or so. There are 6 children, and the children are all grown up, they're adults except for one. So this is the marriage which has subsisted over several years, and I see what you say here, that the concern is over the conduct of the husband which is causing the problem. Now, you're asking from the perspective of the wife, and I think there are 2 things that you're looking at. One is what happens to the properties, and the other is in terms of the children, what happens to the children. The difficulty here is this, that in terms of finances, when we get to a divorce situation, the court really doesn't look at who's at fault. So it doesn't look at the fact that the wife might have sponsored him to come to the United Kingdom. It doesn't look at the fact that it's his conduct which has resulted in the marriage breaking down, and the wife for whom you're asking is innocent. So conduct, innocence, guilt, that doesn't really come into assessing how the finances are going to be split upon divorce. What the court does look at is the needs of the parties. If there are children involved, the needs of the children, who the children live with. Now, if I give you an example, if we were to take the one child out of the equation, we would normally say that that would mean on a long-term marriage, the children have all grown up, you'd be looking at a typical 50-50 split. The situation here is slightly different because there is a child. We don't know what the age of the child is. It would be the case that if there is a divorce now, and the child, maybe the younger the child is, the more advantageous it's going to be for the mother. Let's say, for example, the child is 13, 14 years old, as an example. And if there was a divorce now, then it's possible that it wouldn't be a 50-50 split, because mum, I'm assuming, would have responsibility for the child, and therefore, in terms of a split, mother would get a greater share. Now, there are 2 properties. It may well be that mother gets one property in which the child can live. We don't know what the situation is with mortgages, etc. But mum would be slightly better off because she has responsibility for the child. The problem could arise for mother in the sense that if there is a child that's under the age of 18 at the moment, but very close to getting to the age of 18, it could well be that the properties are split after the child turns 18, 50-50. So it just depends. Normally, in this scenario, it would be a 50-50 split with a long-term marriage, generally speaking. But here, what alters the situation is the fact that there is a child under the age of 18. That may mean that mother has a slightly greater share in terms of the division of the property. So that's basically the situation. Unfortunately, any sacrifices that mother's made in the sense that sponsoring him to come to the UK, being innocent in all this, unfortunately that's not really something which is taken into account. It's merely a case of the needs of the mother, needs of the child, which one looks at going forward. I would advise that this is a complex area. No harm in the wife getting advice. It doesn't mean that you have to proceed with the divorce. You speak to a family lawyer who specializes in finances, so it's got to be somebody with experience in finances. They can give you a rough idea as to how these things normally pan out, and in my experience you could get an advice from a second family lawyer, but once you know what the outcome is likely to be, bearing in mind these are people who do it day in, day out, try and follow the advice, and if you do end up divorcing, try and avoid prolonged litigation, which takes time, is costly. Try and resolve it along the lines of what you have been advised. But thank you very much indeed for that question, and I hope that you are able to resolve this in the best way possible. Now, we've had a number of other questions coming in. I'll just touch upon this question before we go for a break, and it's a question from Sister Rahida, and she's got her nationality, and she says that I am about to apply for my British passport. Who can be a referee for my British passport application? Well, it's got to be a professional person. Normally, ideally, try and go for a doctor, teacher, lawyer, nurse, pharmacist. Try and go for those categories. If not, you can always go for other people who are regulated. For example, it could be like, for example, a postmaster. It could be a minister of religion. So there are other categories you can rely on as well. But thank you very much for that question. That takes us to our next break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses, like measles and whooping cough, is rising.
If we're not vaccinated,
We're not protected.
and could get seriously ill. Risking lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
well, the same effort we put into our baking
Goes into matching prices.
Remarkable. We've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum, welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas. Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen, and as always, a popular way of getting in touch is to send is a message on the mobile number. So a landline number for live calls and the mobile number for any messages that you wish to send. Right, let's look at the next question that's come in. And that's a question from Brother Nasir. This is a question that actually comes up in practice a lot at the moment. And what Brother Nasir says is that a wife came to the United Kingdom on a spouse visa about 2.5 years ago. She has a residence permit which is expiring on 31 December 2024. When does she need to apply for her visa? Does her visa finish on the 31st of December 2024? Now, it's a very good question because this is coming up quite regularly as we get closer to 31st of December 2024. The starting point is this, that the BRP card that you have, the biometric residence permit, that looks like it's like a pink card the size of a new driving license. When it says visa expiry date 31st of December 2024, that is actually, sorry, I should say it's not the visa expiry date, it's the card that's expired. So it says valid until 31st of December 2024. So that's when the card actually expires. That isn't necessarily the date on which her visa expires. So everybody who's got these cards, they've got a card where the expiry date is the 31st of December 2024. So that's when the card is going to be expiring. And what you need to do is register the for an e-visa, and basically that's what it is. It basically means that after 31st of December there aren't going to be any biometric residence permits. Your visa status is going to be online, so there's no physical cards anymore. So when you travel abroad and you get to the airport on your way back, you won't have a card to show them to show your visa status. If you're in employment somewhere and you apply for a new job and you're asked to prove your immigration status, there won't be that biometric residence permit, that card that you can show them which shows your proof or immigration status. There'll be none of that from the 31st of December. So that all cards will expire on the 31st of December. After that date, your status will be proven with your e-visa. So what your wife needs to do, Nasser, is to register for an e-visa. And when you register for that, it will say on the your online UKVI account, it will say when the visa was issued, and it will say when your visa actually expires. So in terms of applying for an extension of the visa, the date isn't 31st of December 2024 when your card expires. It is actually the date on which your visa expires, which you will be able to see once you register for an e-visa. So you do need to register for an e-visa, and that will show what the visa expiry date is. That will mean that you know when you need to apply by. So what the cutoff date is, you'll be able to see that. Now the other place that you can check the visa date is if you look at the email that was sent to you by the Home Office with confirmation that the visa is being granted. So there's a letter that they send. They used to actually give it to you physically, but over the last couple of years they've been emailing decision letters. That letter says, if you look at it on the first page, your application has been successful. Later on, about 3-4 paragraphs down, it's going to say that your visa is granted from this date to this date. So that's the visa expiry date in that letter as well. So that's something that you can look at in order to determine when the visa is expiring. But the best way to do it is, look, we're not too far off from the 31st of December. We're less than 2 months away. The best thing to do is to register your card for an e-visa. And that would be the best way to see when your visa actually expires, and then you can plan accordingly after that. So, Brother Nasser, thank you very much indeed for that question. Now, just going back to reiterating, or just looking at one of the questions that we had before about a breakdown in a relationship. Where there's been a breakdown of a relationship, where the parties have been living together for some 30 years, where all the children have grown up except for one who is under the age of 18. If there are assets, and here the situation is that there are 2 properties, what happens? And what I was saying just before the break, when I actually went into this in a bit of detail, is that when you look at a marriage breakdown and finances, how the finances are going to be dealt with, who gets what, the court doesn't look at who's to blame for the marriage breakdown. So it doesn't look at who's at fault if there's been misconduct on the part of one party. That's not something which is taken into account here. What the court looks at is, for example, the length of the marriage. And here, I think the marriage has subsisted, I should say, for some 30 years. So it's a long-term marriage. And normally what you would look at in this kind of situation, if there were no children under the age of 18, you'd normally look at a straightforward 50-50 split. Marriage has lasted for some 30 years. There are 2 properties. There's no reason why there wouldn't normally be a 50-50 split. However, here the situation is slightly different. There is a child, and I'm assuming that the child will go and live with the mother. So it would normally follow that mother would get a slightly bigger share. However, we don't have the full picture here. If it's the case that the child is about to turn 18, is 17, it may well be that the court would still say, by the time this matter is resolved, the child is going to turn 18, the court may still take the view that it should be a 50-50 split. If the child is much younger, let's say, for example, the child is 12, 13 years old, then it's very possible that the court may take the view that the mother with whom the child is going to live, I assume, should get a bigger share. So in a typical situation where there's only one property, not 2 properties, and the mother is then looking after a child under the age of 18, typically there wouldn't be a 50-50 split. Generally speaking, the mother would get around 70% of the assets and the father would get 30%. That reflects the fact that the mother has the responsibility for the child, so the child's needs also have to be met. So there is a possibility here, bearing in mind there is a child from this long-term relationship, that mother with whom the child will live will get slightly more than 50-50. I think a lot's going to depend on how old the child is. And I did advise before the break that what I would say, and I'm not suggesting we're at the stage now where the divorce is going to take place. There's no harm in taking advice from a family lawyer who's experienced in dealing with financial disputes or who's experienced in dealing with finances. It's worth taking an advice from that lawyer. At least you get an idea from an expert as to what the likely outcome is going to be. That doesn't necessarily mean that you're going to instruct a family lawyer to start your divorce proceedings. You are simply looking at what the possible outcomes are, and if you need to start preparing, you're looking at what you need to do before you take the step of commencing divorce proceedings. So I hope that answers your questions. I did go into that in a lot more detail before the break, but that's a summary for our viewer. Hope that helps. I would advise that you do speak to an experienced family lawyer just to get an idea about where we are with that. Okay, let's look at the next question from Brother Yasser, and his question is quite a detailed one. Let's see whether I can condense it for the benefit of our viewers. And he says, this is about his immigration history. And what he says is that I used to live in the United Kingdom. My visa expired in November 2013. I overstayed for a couple of months and then went to live in Ireland. And I stayed there until August 2015 before returning to Pakistan. If I was to apply for a visa now, we're in 2024, will that slight overstaying in November 2013 affect my visa application now? Two things, Yasser, I would say to you on that. One, it shouldn't affect your visa application now. This is something that occurred more than 10 years ago. So I can't see why it would affect your application now. It appears from what you're saying to be a simple case of overstaying for a short period of time. It doesn't look like you were removed at the expense of the Home Office. It looks like a simple case of overstaying for a short time before you went to Ireland. Once you've left the country, you've spent a couple of years in Ireland, that's got nothing to do with the Home Office here. Different country, completely different to overstaying in the UK. Short period of overstaying in 2013 is not going to affect your application now. To be quite honest, if you have overstayed, generally speaking, what happens is that you're prevented from applying for about a year. That doesn't apply to spouse visas. If you're wanting to come back as a student, come back as a skilled worker, you might be prevented from applying for a year. There are longer bans when different circumstances apply. But yes, as far as your situation is concerned, this is something that occurred more than 10 years ago. It's not a problem for you. The second point I wanted to mention is that although it's not relevant in terms of your ability to apply for a visa successfully to the United Kingdom, you still have to mention that problem. You still have to mention that refusal. You still have to mention your overstaying. Because if you don't, and the Home Office pick up on that, that could be problematic for you. But yes, sir, I hope that answers your question. Not a problem for you, but explain it in your application. We're taking a short break. Inshallah, we'll be back in the next couple of minutes. See you then. Assalamu alaikum.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
Well, the same effort we put into our baking
Goes into matching prices.
Remarkable, we've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Our generation's risk of illnesses, like measles and whooping cough, is rising.
If we're not vaccinated, we're not protected. And could get seriously ill. Risking lifelong disabilities.
Are your child's vaccines up to date?
I'm in. Now, you ready for a good day?
He was a scientific hypothesis. She was a clinical study. And the future breakthrough that could cure her is closer than ever. With our research, we can keep saving lives like hers. Donate now to turn science fiction into reality.
Sainsbury's? Are we made of money?
Hey Sainsbury's, explain it, will you?
well. The same effort we put into our baking
Goes into matching prices.
Remarkable, we've actually come in under budget.
Get it now?
Already got it.
Sainsbury's. Good food for all of us.
Assalamu alaikum, welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live, please ring on the landline number which appears at the bottom of the screen. As always, a popular way of getting in touch is to send us a message on the mobile number which also appears at the bottom of the screen. So mobile number for messages, they will be fed through to me here live in the studio, and I will be able to answer those questions as they are fed through. Okay, let's look at the next question that's come in. And it's a question from Brother Asjad, and it's to do with sponsor licenses. I think we used to get a lot of questions on that, but I think they are becoming less popular at the moment. And what Brother Asjad says is that, are there any changes coming in terms of sponsoring people from abroad applying for a sponsor license? I understand that the Home Office is very strict at the moment and refusing applications. Is that correct? Now, Brother Asjad, in terms of sponsor licenses, in terms of sponsoring workers from abroad, you're right. Although it is possible still to apply for a sponsor license and sponsor somebody from abroad, that's 100% possible. It is correct that the Home Office is scrutinizing these applications very carefully, and a lot of applications are being refused. So, what can you do in order to make a successful sponsor license application? There was a time, I think 6 months ago, a year ago, when it was just a case of submitting some simple documents and the application going through. Now you have to put a lot more work in. There's a need to be a lot more accurate to get the application right. So, for example, it's not just a case of submitting the mandatory documents that they're asking for. You have to explain why you're applying for a sponsor license in a bit more detail. And the most important thing is that you need to be prepared for the Home Office to undertake a compliance visit, undertake some kind of scrutiny. You have to be prepared for that. So normally the Home Office will conduct a Zoom interview, an online interview with the person who's been nominated as the authorizing officer. And the Home Office will ask questions about your understanding of the sponsor license regime, why you need to sponsor somebody, your HR practices, etc. So the Home Office will look at a number of things in terms of your ability to comply with the immigration rules. So, for example, if you've applied, let's take an example, you're a restaurant and you've said, look, I've got 10 people working for me, I need to employ more chefs and I can't find them here, I want to sponsor them from abroad. Perfectly fine, makes sense. You've got a proper business there, you're already employing a number of people, and what you now want to do is employ people from abroad in what is, I think they generally understand, it's a difficult post to fill here in the United Kingdom anyway. Now, the problem is that is just the first part of the application. They understand it's genuine, your application, they understand your business is trading, they understand you've got staff there, they understand you've got a need for people to fill certain posts. But that's just the starting point, Asjad. What they also want to look at, and this is where the difficulty arises, is all the other things. It's compliance, it's HR. And with smaller businesses, it's difficult because smaller businesses are concentrating more on running the actual business as opposed to looking at compliance. So compliance is really the issue. They are looking at, Do you conduct your right to work checks? Do you make a note of when people's visas are expiring? Do you know what to do when somebody's visa actually expires? Do you have to use the employer checking service? Are you paying your people properly through bank transfer? Are you keeping a proper record of people's absences, whether it's holiday, whether it's sickness absence? Do you understand your obligations if you were given a sponsor license in terms of your reporting obligations? Do you understand that you need to keep the login details, etc., safe? Nobody else can have access to them. So what the Home Office is doing is trying to assess a number of these things to look at your understanding of the HR requirements, record keeping requirements, understanding of your responsibilities for somebody who has a sponsor license. So the problem is really on the second front. It's not whether you're genuine, trading, whether you're profitable, whether you've got a need for that post to be filled. That's all fine. The vast majority of businesses of a reasonable size can demonstrate that. The difficulty really is over the second bit, which is to do with compliance, human resources systems in place, etc. Most smaller businesses will struggle with that because they concentrate on running their business. And in the example that we've given, if it's a restaurant, they're concerned about running the business, getting the customers in, marketing, getting the food out right, making sure that the business is profitable, employees are paid. What's being asked here is compliance, whether the requirements in relation to the HR requirements, which overlap with certain immigration law requirements, whether they're being fulfilled or not. That's where the difficulty is. So yes, applications are still being approved. The scrutiny is much greater, and what you do need to do is take proper advice so that not only can you be guided in terms of the application process, the submission of documents, but more importantly, you can be guided, you can be trained, you can be told about what to expect at the second stage if there is an interview. And even if we follow this through, if we move on from the license has been granted, you want to sponsor somebody from abroad, for example, if you then sponsor somebody, what happens is that it is still likely that the person that you sponsored is going to be interviewed as well. So that's the other type of interview where they're looking at whether this person that you've recruited, whether that person is a genuine person who will be filling your post in the United Kingdom. What kind of experience does this person have? What understanding do they have of the role? Do they understand what they'll be required to do, etc.? So that's the other area in which there is much more scrutiny, which was never the case before. So at the initial stage, when you're applying for a license, there's much more scrutiny. If you've got the license, once you're sponsoring somebody, a skilled worker has applied to come and join your business, they could be interviewed as well to see whether this is all genuine or not. So it's not straightforward anymore. So please do bear that in mind. Now, I think we are heading towards the end of the show. We've got probably time to take one more question, and that's a question from Sister Raisha. And what Sister Raisha says is as follows: that currently I am looking to sponsor my husband to come to the United Kingdom. I work for an agency. Can I rely on agency employment in order to sponsor my husband to come to the United Kingdom? Thank you very much indeed for that question. Now, interesting question. The short answer is there's no problem. You can rely on agency employment in support of your application. So, in support of your husband's application. So there's no problem on that front, Raisa. The issue is this, really, that if you're in employment through an agency, you have to look at your income quite closely. It might be, I think most likely you're hourly paid, whenever you work, you get paid by the agency, which is fine. Two things you need to bear in mind. First of all, you need to be employed by the agency for 6 months. So that's the first issue. You must be employed by the agency for 6 months for it to work. So if you've been employed for less than 6 months, the rules are slightly different. You need to show your income over 12 months. So ideally, you've been employed by the agency for 6 months. What you then look at is what you've actually received in that 6 month period. So count up what you've received. At the moment, the requirement is that you need to be earning £29,000 a year. Half of that, £14,500. Have you earned that from that agency where you're working in the last 6 months? If you have, if you've been there for 6 months, if you've earned £14,500, there's no problem. You can rely on agency employment in support of your husband's spouse application. So, Rasha, I hope that answers your question. In terms of evidence, you'll get a letter from the agency confirming your employment. You'll put your 6 months of pay slips in. You'll put your 6 months of bank statements in, which show your income going into your bank account. So that's the kind of evidence that you will be submitting in terms of your employment income. But in principle, there's no problem at all in relying on income from an agency. So don't worry about that. But thank you very much indeed for that questions. If you're not sure about anything else, please do get in touch. We are coming to the end of the show, but if you do send us a question, inshallah, I will pick it up next week and deal with that. That takes us to the end of the show. Inshallah, we'll be back next week at the same time. Until then, Assalamu alaikum.